All right, so let's get back to the serious stuff here, which is we told you guys, I'm guessing this was a couple of months ago at this point, Adam, about DraftKings coming after Fanatics for a what was allegedly at the time went on kind of behind the scenes of the acquisition of their head of VIP. And you and I made a very, I think, a point that isn't really talked about a ton of stuff in the other articles that are written out there. And this isn't just like, oh, let's pat Matt and Adam on the back. But, you know, yeah, the case in and of itself and the stuff that went on is just bizarre. But I don't think people realize just how valuable someone who holds the keys to your VIPs like is in a business like this. And so when people look at this and like go at it and so what is it, what, you know, whatever, I get it. It kind of sucks, but what's the big deal? And I think that some of the articles I read don't even mention about like why this is such an incredibly big deal. But as we said, and I truly believe this, outside of like the intellectual property of the code to the app, right? Like whatever and stuff like that. Like this might be the most important information in that company.
It is the most important information in that company, without question. If you understand the amount of money that is flowing through your VIP customers and the fact that when you look at it not only as those customers potentially leaving your business, but going to a direct competitor, it is a double hit when you think about it in that regard. So let's get to the news of what actually happened here this week. DraftKings was victorious in winning a preliminary injunction against Michael Hermelin, its former head of VIP, who left suddenly during Super Bowl week to go to Fanatics in a scheme that you have to read about at Legal Sports Report to truly understand the movie level of plot that went into this move. It's beyond anything I've seen in my years of covering this industry. But what does that mean for us practically right now? It means that the district court in Massachusetts, in giving that preliminary injunction, essentially said that there is a likelihood that DraftKings will succeed on the merits of its case when this is finally heard. In the short term, it means that Michael Hermelin is enjoined from using any of the information he might have potentially gained or doing anything that he would have done in a similar role at DraftKings for the 6 months prior to him leaving DraftKings for the term of his non-compete, so long as that non-compete stands in the future of the legal case here, because Michael Hermelin is challenging that non-compete in court. Now, what does that mean in practice? It means that from the spokespeople that we've talked to, the people behind the scenes at Fanatics, they've said, you know what, it's a big business. There are other things that he can do in between the time when he is enjoined and when he is ultimately allowed to move on here. I have questions about how the enforcement of any of this ultimately works, like who talks to who behind the scenes, and how does information about a client who might potentially be interested in moving from one sportsbook to another come across. There's so much here involved. Matthew Waters has been following the case for us at Legal Sports Report. I encourage you to take a closer look at the article that he put up this week for the latest on what's going on. But it is notable at the very least that DraftKings has won that preliminary injunction, and the court has at least said, okay, based on what we've seen so far, we believe the DraftKings side more than we believe the Hermelin side. There is, of course, much legal wrangling still to come here.
Muddying the water even more, the FTC coming out in the last week and saying that non-compete clauses cannot be enforced, except they did carve out something for senior level executives and all that, Adam. And, you know, this is an aside to all of this. And I understand whether you're on the side of non-competes or not. I think if you kind of look at it rationally and say, like, look, a guy 10 rungs down the ladder, if he needs to improve his position in life or something like that, like he should be able to do that freely. I don't think that we should be going in and trying to prevent that from happening. However, I do think that there's merit to some of these people who, as we kind of laid out at the top of us talking about this, that literally could cripple a business with what they do, with the knowledge they have, with the Rolodex that they have and all that stuff. Like, I think there's some merit to all of this, right? I think there is merit to some non-compete clauses. I don't think the vast majority of them probably are anything that need to be in place. Like I said, if you're way down the ladder if you're trying to move up in life, like who am I to try and keep you from doing that? But dudes who do put themselves in situations where you are now holding the keys to stuff that could, in theory, I know we're talking, it's a bit hyperbole when I say that, but in theory, cripple a business or at least really dig into a business's bottom line. I think that there is some merit to some non-compete stuff and not being able to just jump ship and go and do that. So I'm again, that's just my adding a little personal opinion here to our news podcast.
For more legal advice, go to brownandcandy.com where we will represent your interests for the low, low price of free. Adding a little bit of context here also, the court did note that what Matt mentioned about the carve-out for senior executives applies here. The non-compete is still valid in the case of Michael Hermelin. So even though we saw the FTC essentially say these are all null and void going forward, it does apply in this case.